Additional evidence from the state.
State
Rest, okay. All right, ladies and gentlemen, I'm going to ask you to step into the jury room for just one moment. I'll be bringing you back out momentarily to let you know how we're going to proceed. All right, counsel may be seated.
Can I take that one housekeeping issue first?
Yes, one housekeeping you can do is take the screen down so I can
Oh, I will, Judge.
see the defense. No, I don't think we need it for... What is the housekeeping issue that you...
Judge, I moved those exhibits in as 1B and 3B. So 3, I should have, they were actually, the whole package is 1A through C. So what I asked for Mr. Shahadi's phone records that are just limited to those dates be 1D. And then for Ms. Dippolito's, her package is 3A through D. So I would make her cell phone records and text messages as 3E.
You're just renumbering?
Just renumbering, changing 1B to 1D and 3B to 3E.
Okay, I mean, that's, it doesn't matter what they're marked. So it'll be 1D in evidence over objection and 3E in evidence over objection. Yeah, I'm confused too.
Because what happened is the certification is in 1A, 3A certifications, we do those in, but they already have a B and a C that they move in, so that's all it was.
So they're only moving in part of the record. All right.
So it would be 1A and 1B. So that would be 1D. This is already you want, oh, that's fine. Then we can leave it as 1D and 3D.
Just leave it as marked then. Okay.
All right. Thank you.
Okay. All right, let's talk logistics here for just a minute, because I want to figure out what our schedule is going forward. I've got renewed motion for judgment of acquittal I have to hear. I have final argument on a couple of motions I want to hear. I need to have a charge conference in order to get the jury instructions complete and ready. And what I'm wondering is, how long do the parties think it's going to take for us to accomplish that?
I think all motions should take at most 30 minutes.
Okay, and then how long do you think it's going to take us to get the jury instructions in shape that they can be used? 3 minutes?
I think it's not 30. I think if you do an hour.
I didn't know what the 3 meant. All right.
Yeah, I think if you do an hour for both.
Okay, so how long are the parties anticipating for closing?
Well, I'll send first.
Everyone always does this when I ask that
Well, I'm
question.
gonna
Whatever
be-
they want, whatever they want. It doesn't matter.
I estimate probably 45 minutes.
45 minutes, okay. State?
Oh, I don't know. I'm going to play some videos in closing, so my part's probably going to be close to an hour.
Well, you get equal time,
Yeah, so I would say an hour and a half.
90 minutes aside. Okay. Well, obviously, Mr. Claypool, you get equal time. I don't know whether you'll use 90 minutes or not, but, all right, given the fact there are videos to play, then given the trial, I think 90 minutes is probably reasonable. Stretching it a bit, but probably reasonable. So what I'm trying to figure out is, what do I do with these folks this afternoon? I mean, I can try to get a charge conference done, try to get a ruling on the motions, get the jury instructions finalized. If that takes an hour, we're at 3:15.
I'm fine. I'll go, Judge, and if you want to let them go for the day and then they can finish up tomorrow, it's fine for me.
Well, the question is, do I keep them here? I'm not going to keep them locked up in that room for an hour. Mr. Claypool, do you have a preference?
I suggest you maybe let them go for an hour, come back. And I'd like before
I'll be happy to try.
Maybe we try to expedite the time on the motions, maybe that might help a little bit.
I have no problem expediting this trial, believe me. I have no problem with that at all. I just want to make sure that we think that we can get more done this afternoon.
We asked the court respectfully, what's the latest we can go today?
6
Keep
o'clock.
the court open without you getting in trouble.
Without me getting called in front of the chief? 6 o'clock.
Okay, my vote would be, let's work ahead and try to get the closing done today. Good.
Mr. Williams, any problem with that?
Okay, we're ready.
Okay. What I want to do, though, is I don't want to keep them sitting in that room for an hour. If they want to go get a cup of coffee, I'm going to have them come back in an hour. I'll obviously instruct them not to discuss the case, all the usuals, but I don't want to keep them in a windowless room for an hour. If they want to go get a cup of coffee, that's fine. So let's go ahead and bring out the jurors.
Jury entering.
All right, counsel, you may be seated. Welcome back, ladies and gentlemen. There are some legal matters I have to take up before we're ready to proceed with the closings. It's going to take us some time to do that, so I don't want to keep you in that room waiting on us, because we estimate it's going to take us about an hour to do that before we're ready for closings. And so what I'm going to do is to give you the freedom. We're going to let you go downstairs, get a cup of coffee, do whatever you like to do. With limitations I'll give you in just one moment, and you've already heard before, but with those limitations, we're going to let you go downstairs, get a cup of coffee, do whatever you like to do while we go through these legal matters to make sure we're ready to do the closings. You come back, you'll get your legal instruction, that is the law that you have to follow in this case, and we'll go into the closing arguments. Now, all the evidence is in, but you've not heard the legal instructions. That is the law you have to follow in this case. You've not heard the closing arguments of the attorneys. And so, as I mentioned at the beginning of the case, until I actually send you back to begin your deliberations, at this point you still cannot, even though all the evidence is in, you still cannot discuss this case amongst yourselves or with anyone else. You cannot do any research, and you obviously cannot listen to or read any news accounts of the trial. So I'm going to give you about an hour break. If you're back in an hour, we'll hopefully be ready to go. We're not going to keep you upstairs. You could go downstairs, do what you like to do, and we'll see you back in an hour. All right, counsel, you may be seated. Let's start with motions. I don't care where we start.
We can quickly start with, we're going to renew our motion to dismiss, or the alternative motion to exclude evidence and testimony, or the alternative motion for a spoliation instruction based on the failure to preserve, loss, or destruction of evidence. And we've been through most of the facts, so I'll just add a few additional facts.
This is the Arizona versus Youngblood argument?
The Trombetta and Youngblood, yes, Your Honor. And there's just two prongs real quick. First, the gathering and the collecting of evidence. I know Your Honor found that we argued there was no distinction. Your Honor found that there was a distinction. But just for purposes of preserving the record, I'm going to refer to former Sergeant Ramsey's testimony, that they could have got a wire. Sergeant Sheridan said it was my, and I'll quote, effing investigation. They had 2 hours to get that. And Captain Bonifair also testified there are other ways to get the tape, or pardon me, to get a recording. They could have given different devices to Mr. Shihade to preserve the integrity of the investigation and record the conversation between Dalia Dippolito and Muhammad Shihade. And I just renewed my argument that the initial interview and the 30 phone calls, and we'll amend the initial motion from 500 plus phone calls to 30, also could have been gathered and collected, and there's no distinction. Now, as to prong two, that's the loss, destruction of evidence. And Your Honor's previous ruling was that there actually has to be loss, failure to preserve, or destruction, not failure to gather evidence. And based on that, it's our contention, following Mohammed Shihadi's testimony, and this is in regard to the Chili's incident. He testified that he knew he was wired and it was recorded. He remembers them putting the wire on his chest. He remembers them joking with him afterward about the things he ate and the things that happened in there, which would necessarily indicate that at some point there was a recording of the conversation at Chili's. Now we do in fact have a either loss of evidence or destruction of evidence claim. No one has directly testified that the recordings malfunctioned. They all testified that they heard from a third party that they malfunctioned. Bonifaire testified he found out the day after. Ramsey testified that he found out in his car he was not there. So there's no witnesses saying it actually malfunctioned. The only affirmative testimony we have is from Mohammed Shihadi, who's saying, look, they pulled my shirt up, they strapped the wire on, I remember the conversation, I remember them joking about it, there was a tape. So assuming there was a tape, Judge, that was either lost, failed to preserve, or destroyed, under Sobel, and that case has not been withdrawn by the Florida Supreme Court subsequent to Arizona v. Youngblood, the state has the burden of showing whether that was potentially useful or exculpatory. And the state simply can't meet that burden. I mean, this falls under Trumbetta. If they can't meet that burden, and good or bad faith does not matter, and there's necessarily a due process violation. So with that, we'd argue the case should be dismissed. Your Honor should exclude Waddy Jean's testimony, or at the very least, if Your Honor does not find those sanctions appropriate, Ms. Dippolito should be entitled to a spoliation instruction with an adverse inference. In addition to it being a due process violation, this tape being lost is necessarily a discovery violation.
How could it be a discovery violation?
Because the police were in custody of discovery. That discovery was not...
If it never existed, how can it be a discovery violation?
We're not saying it never existed. We're saying based on Mr. Shihadi's, and this is solely in regard to the Chili's reporting, that based on Mr. Shihadi's testimony, he's the only person who could testify to this, because everyone else heard from secondhand that the wire malfunctioned, that there was a recording, and that they were joking with him about the recording.
He didn't testify there was a recording. He testified that they were able to hear what he was saying.
Which would be a recording. He was wired.
Not necessarily. It could be. It could not be. It's not. I mean, I don't think you can necessarily conclude that there was a recording because they could hear.
Well, there was nobody inside Chili's.
Correct.
All officers acknowledged that and testified to that. They only put a recording device on him. I mean, all testimony we've heard from every witness was that the recording device on him malfunctioned. So the only inference that can come from that is that the recording is that there was a recording and now that recording's gone. And there's no testimony to the contrary. And if that's the case, not only is it a Trumbetta issue, but it's also a discovery violation. Because that was in the possession of the police. And like the fact that it was in the possession of the police, it was in the possession of the state, and that was not turned over to defense counsel.
Okay, I need to hear from State.
Every credible witness to see that.
Okay, anything further on Arizona versus Youngblood?
The last thing I would say is not a single credible witness disputed that. They all said they heard from somebody that it malfunctioned. The state didn't find one witness who testified that it actually malfunctioned.
Okay. My holding is as follows. My interpretation of the law following Arizona versus Youngblood is that there must be evidence that a particular item existed at one time and was later lost or destroyed. There is no competent evidence in this case to suggest that a recording existed at one time and was lost or destroyed. The only evidence is that there was a malfunction. There's never any tape put into evidence initially back when this occurred. No one's ever testified to hearing a tape or seeing a tape. And so with respect to the Chili's tape, there was, in my view, based on the competent evidence, no evidence that the tape actually existed and was later lost or destroyed. With respect to the phone calls and the meeting with Mr. Shahadi at the police station, which were two other bases for the dismissal, there's simply no evidence at all that those tapes or recordings existed. In fact, the evidence is to the contrary. So again, because it didn't exist and was later destroyed or lost, it is not a violation of Arizona versus Youngblood and its progeny based on my review of the case law, nor is it a discovery violation, nor based on that fact would I give a spoliation instruction, because it didn't exist and later was spoiled or lost. So I'm going to deny the request for a spoliation instruction and deny the motion to dismiss.
Thank you, Judge. One last, I'm sorry.
No, I was just going to say, what's the next motion?
Well, one last point for appellate purposes, I respect Your Honor's ruling. We would just say that if the fourth were to decide that the police have a duty to gather evidence, I know we had a dispute about that a few weeks ago, there was bad faith on behalf of the police based on Sergeant Ramsey's testimony that he tried to get a wire to gather evidence, and Sergeant Paul Sheridan basically told him to, I don't want to use the expletive, Judge, but that it was his investigation and to get the F out. So that would establish bad faith.
Yeah, my ruling is we don't get there. So if they find that your argument has merit, then the analysis would be different. But State versus Daniels is the fourth DCA opinion, 699-837, Southern Second. I think it supports the proposition that the document or item in evidence must have actually existed and then later have been lost or destroyed. So obviously, I don't think we get to the good faith, bad faith part of the analysis, because I don't think we have a lost item or destroyed item. So if they disagree with me, obviously the analysis would be different.
I'll rely on my previous arguments about Daniels.
Okay, second motion you want to argue?
Renew our amended motion to suppress all audio and video recordings between Muhammad Shihadi and Dalia Dippolito. And this is...
This is consent and voluntary.
Correct, Judge. And Mr. Shihadi testified at trial to several things, and we'll start with the consent. He said he did not consent. He did not read the entire confidential informant packet. He felt fooled, confused, lied to.
Wasn't there a written consent shown to be put in evidence when this motion was first filed?
Yes, he said they went through it in a minute, they flipped through it.
Well, not the CI, the consent to be recorded.
That's part of the CI package, Judge. They didn't read it to him, that he was confused, that they flipped through it. He did not know what he signed. I think he didn't even know what the last page was. And that was one of the factors discussed, I believe, and I don't know the case in front of me, Judge, it might have been Jones, where they rushed through the CI packet. And I apologize if I'm wrong on that, I don't know the case in front of me.
All right.
He also testified that he was threatened by prosecution, and he made it pretty clear that he was confused about the packet. If someone's confused, if they're rushed through a confidential informant packet, that's not voluntary. That's not voluntary consent, and therefore, all recordings between Muhammad Shihadi and Dalia Dippolito have to be suppressed. If Your Honor disagrees with that, we would further argue that he withdrew his consent. He said several times, I told him he wanted to withdraw. This court has previously found him credible at the last hearing. One moment, Judge. Oh, he even testified that while at Boynton Beach Police Department, they took his keys to move his car, and he didn't know he had the camera in his car. Now, and this is assuming Your Honor does not find the first prong in regard to the confidential informant packet, but I'm going to draw your attention to Minati again. I know we've had some issue with that case, and I think I know where we've had issue, and I think it was a factual problem more than a legal issue. The camera in the car was the one picking up the recording, not the wire. That audio, that camera captured audio and video. And I went through Minati a few more times, and What it states is every circuit court to address the issue has concluded that Title III does not regulate silent video surveillance. We conclude that silent video surveillance is not covered by Section 934.02 or 934.10. And I would agree with Your Honor that if I was walking in the hallway of this courthouse and there was a surveillance camera with no audio on it, that would not be subject to that statute, the Florida wiretapping statute. However, because they specify, and I'll read one more quote, federal decisions uniformly have held that the Act's provision do not apply to surveillance that fails to capture the substance of any wire electronic or oral communications. Several federal cases have held that the Federal Act does not apply to silent surveillance videos. The court held that silent surveillance videos were not covered by the Federal Wiretap Act, reasoning that the Act did not apply to interception of visual images without oral communications. So the inference from that is that it does apply to video cameras with oral communications.
And for the oral communication, you must have consent.
Correct. And we would say that one, he did not consent.
Well, I know, that's but that's your first argument. This is a fallback argument.
Yes, that he withdrew his consent, that he had no idea that camera was put in his car. But he testified time after time, he told them he wanted to remain anonymous, he did not consent, it was not voluntary, he was tricked, he was confused. He basically withdrew his consent, he didn't know the camera was in the car. And with that, Judge, we would renew our motion and ask that all audio and recordings between Muhammad Shiati and Dalia Dippolito be excluded.
All right, state.
That they just brought some previous evidence presented in arguments. Right.
Anything additional you want to add?
Not this time, Your Honor.
Really nothing to rebut. He didn't say anything other than previous. Okay, the motion is denied. I believe, based on the competent evidence presented, he did consent. In fact, he did a sound check when he began the tape. And in the state, in response to the motion, played additional sections of the tape which indicated the basis for which he went through it. We'll just have to agree to disagree on the effect of 934 in Minolti. I thoroughly believe that what the case stands for and what other cases on this subject matter stand for is that the only time you need consent is if there is interception of oral communication. And so consent must be obtained for that. Consent was obtained for that. The motion to suppress is denied. What's the next motion you want to argue?
Probably the JOA. Just one other back, Judge. The wire in the back of the car was not the same as the camera. There's a
It
wire.
doesn't, that's where you and I are having a fundamental disagreement.
Sure.
It doesn't matter. What is regulated under Chapter 934 is the interception of oral communications, no matter in what form. Doesn't matter whether it's by a camera, microphone, whatever form, under 934, if you're going to intercept an oral communication, there must be consent. 934 expressly does not apply to a video. And so the consent, whether it's being taped by the camera itself or by a hidden microphone, doesn't matter. That would require consent under 934. The visual part of it does not require consent under 934. So you're moving now to motion for judgment of acquittal?
Yes.
Okay.
Except 1 minute on those. Under the higher standard, Judge, we move for a judgment of acquittal on the basis that no reasonable finder of fact could find that Ms. Dippolito had the intent for solicitation. I begin with the interaction between Dalia Dippolito and Whitey John in the car, where she promised to provide him with certain things, which she did not provide him with, which shows intent. The state cannot rebut the lack of evidence from the missing phone calls and from the unrecorded or destroyed Chili's incident. One moment, Your Honor. No reasonable finder of fact can find that Boynton Beach did not threaten Muhammad Shiati with prosecution to ensure his cooperation with his investigation, that they did not impose a 72-hour deadline within which Mohammed Shiati had to secure Dalia Dippolito's participation in sting operation, that they did not force Mohammed Shiati to wear a wire during the course of the investigation, and thus pressure Ms. Dippolito into continuing with this investigation. This all goes to intent, Judge, the intent element of solicitation.
Okay.
And furthermore, they could not prove, no reasonable juror could find beyond a reasonable doubt that the police's conduct did not amount to egregious police misconduct or objective entrapment.
But that, again, depends on whether the state has any burden to prove that it was not objective entrapment. That goes to the issue of whether objective entrapment is even an issue for the jury.
So we'd ask that you defer ruling until you hear argument on that in regard to the JOA.
Why don't we hear argument on that now?
Sure, Mr. Green is going to cover that, Judge.
Fine.
Good afternoon, Your Honor. Thank you for having me. The fundamental problem we have, Your Honor, here is that we are not at a motion to dismiss stage of the proceedings. We're here at trial. And then I submitted briefing on this, so I won't belabor the point. Our main contention is that we believe that the disputed issues of fact should be found by the jury and not by Your Honor. Dippolito is right to trial by jury. The objective entrapment claim is suffused with factual disputes, starting with whether or not Mohammed Shiati, when he first... I'm sorry, Your Honor.
Okay, was the mic off?
It was shifted over this.
All right, I can hear you better now.
Would you like me to start over, Your Honor?
No, I heard what you said. I just could hear you better now.
Okay, thank you. So again, I mean, starting with when he first arrived, or first made his call, whether or not he was intending to report domestic violence, or whether he was intending to report the crime of solicitation, that's a factual dispute, and we believe that the jury ought to have a say in that. Moving to when, what happened when these unrecorded phone calls took place, whether or not he threatened her, that's a factual dispute. If the jury finds in our favor on that, we believe we can satisfy objective entrapment as a matter of law. Sorry, Your Honor, I had my... There's a factual dispute as to whether or not Mohammed Shiati was tricked and or coerced into becoming a confidential informant. We understand and we respect, Your Honor, has found for the purposes of other motions that he did not, that he voluntarily consented. But we respectfully submit, Your Honor, that we're now at trial and that should be something that should be addressed by the jury. And we would like to submit that to the jury. We also believe that there was competent evidence that the Boynton Beach Police Department imposed a 72-hour deadline. We believe that.
I mean, let me just ask you this.
Yes.
There can be disputed issues of fact on a whole host of things, but they have to be a disputed issue of fact on a legal defense that can go to the jury.
Okay.
And if objective entrapment is not a legal defense that can go to the jury, there can be all kinds of factual issues, correct? But they're not issues that go to a legal defense that the jury gets to decide. And that's the issue we're at right now. Objective entrapment, you've asked for an instruction on objective entrapment. And the threshold issue is that an issue they get to decide, objective entrapment?
And we believe it is, Your Honor, and we rest primarily on really the fundamental theory that this is a mixed question of law and fact. And under Gowden, the United States Supreme Court question, that's an inquiry that traditionally does go to the jury, a mixed question of law and fact. We would distinguish cases such as Blossom, where it was stipulated that these are the facts. In Blossom, the state stipulated these are the facts, and it was decided on a motion to dismiss. And again, we would rest on cases like Delis, where the 4th District expressly said that whether or not she was raped by the confidential informant whether that was a factual dispute that was appropriate for the jury to resolve. Again, the Clayton case is similar in its holding. That it's premature for a trial court judge, when there are disputed issues of fact, to decide the question of objective entrapment, and it's more appropriate to present that to the jury to decide. We recognize that there is language in other cases that says objective entrapment is a due process violation, and that is...
Including two Supreme Court cases. The original Supreme Court case that created the concept of objective entrapment in Florida was the Cruz case.
Yes, Your Honor.
And before that, there was no objective entrapment in Florida. We adopted it because of certain federal precedent that was created. And the Florida Supreme Court adopted in Cruz the subjective-objective test. I think that was the first pronouncement. That case, in addition to the Glosson case, which are both Supreme Court cases, clearly say it's an issue of law for the court, not for the jury.
Your Honor, I understand that, but we respectfully believe that those cases don't stand for the proposition of when there are disputed issues of fact, and Supreme Court cases are legion, that this is the fundamental bulwark that prevents a defendant, and this was so important that it was enshrined in the Sixth Amendment of the Constitution, that a defendant has the right to a trial by jury, and encompassed within that right to a trial by jury is to have all facts which are material to guilt or innocence to be decided by the jury. And, Your Honor, if you believe that the ultimate issue, the legal issue of whether objective entrapment, whether that burden has been met, is for you to decide, we would respectfully ask the court to give special interrogatories in connection with the verdict form to allow the jury to decide certain questions of fact. Otherwise, Your Honor, it's a bench trial embedded within a jury trial, which is inherently strange. I respect Your Honor and Your Honor's authority and Your Honor's ability to find facts, but the reality is we're in the middle of a jury trial, and we believe that within the Sixth Amendment right to a fair and impartial jury, encompassed within that is the right to have all questions that are material to guilt or innocence to be decided by the jury.
Correct, if it's a legal defense.
And there's no real difference between subjective entrapment and objective entrapment insofar as both are legal defenses, both are rooted in due process. Subjective because there are factual disputes, that's why it's presented to a jury. Normally, objective entrapment is a pure question of law. In this particular instance, Your Honor, we believe that it's a mixed question of law and fact. And Your Honor, I have nothing further to add. I don't mean to belabor the point.
No, that's okay. That's fine. State.
Does not believe that they're entitled to objective entrapment as a jury instruction. I gave the defense two cases this morning, or just a video that I located, I think, on this issue.
I'm familiar with both those cases.
I thought you might be. From the state's position, objective entrapment is a question for the court. When we look at Glosson, I think Glosson's 100% clear that due process defense based on governmental misconduct is an objective question of law for the trial court as opposed to the subjective predisposition question submitted to the jury. Then in Munoz v. State, 629 Southern 2nd, 90, decided also by the Florida Supreme Court in 1993, they rejected any construction of 777.201 that would require such an issue of law to be submitted to a jury. And in the Blanco case, which is 896 Southern 2nd, 900, decided by the 4th DCA in 2005, which I will point out is actually was decided after the Del Geis case that they've cited to, that the case was dismissed by the trial court based on entrapment. The DCA reversed instead of factual dispute and held that the jury may find on subjective entrapment, but nowhere did they mention a jury finding on objective entrapment. And they had reversed the court's dismissal based on objective entrapment. So I think clearly from a reading of that, the fourth is saying that subjective entrapment can go to a jury, but objective entrapment is a decision by the court. I think, too, when you look at Campbell, the court cited to you yesterday, the 935 7th 2nd 614, objective entrapment's a bar to prosecution, and I equate it to stand your ground. It's a statutory immunity. I think that objective entrapment is in essence the same thing, and I think when a court looks...
I would disagree with you. Objective entrapment is a due process violation. I think Mr. Rosenfeld made a sort of an analogy to stand your ground too, in terms of having the self-defense decided by a jury later, but courts have held that that's not a due process violation.
I'm looking at it just in the sense of it's a decision that when I agree it's a due process violation, but I think it's
an immunity decision.
Right, and I think that the court's job is to evaluate a case and the evidence that's been put forth at a jury trial, and deciding what are the proper jury instructions in order to appropriately instruct the jury on the law. And if the court were to sit here and make a finding that objective entrapment applies, then the court, I think, should have dismissed the case. Do you understand the equation that I'm making? That if a court's saying, well, I think objective entrapment exists, then the court would have been required to dismiss the charges based on that finding. So I think that's why it's granted the way it is in the law, that it creates this up front that the court, if it makes the finding, can dismiss the charges. And in the Campbell instruction, the court had no issue with the fact that the trial court didn't give the instruction on objective entrapment.
No, that court held that subjective entrapment was a proper instruction.
Right. A lot of the other cases they cite to, I would say, are out-of-state cases. They have absolutely no binding effect on this court, unlike the Supreme Court cases that do state that objective entrapment is not a question for the jury. That's our argument.
Okay. Rebuttal.
Thank you, Your Honor, and I'll be brief. In Munoz, it was, quote, given the unrefuted facts of this case, so that the facts were unrefuted, it was on a motion to dismiss, and that is at page, 101, near the very end of the majority opinion, given the unrefuted facts in the case. So the facts were unrefuted, it was on a motion to dismiss. Our proposed rule of law is completely in accordance with that. The same could be said with Glosson. The facts were stipulated to by the state. So we're not in a position that we are today, where we're at trial and the facts underlying objective entrapment are in fact disputed. It's worth noting that the state took the exact opposite position in the 4th District. They said that it was based on disputed issues of fact and that it was an affirmative defense. And we provided Your Honor with quotes from their briefing. So it's interesting that they're taking this position now, that it confers immunity from prosecution at the outset. It's also worth noting, Your Honor, that the 4th District denied our petition. So if Your Honor's view is correct, that it's immunity full stop from prosecution, then presumably they would have allowed that to go forward. They didn't deny it, they dismissed it, presumably for lack of jurisdiction. So they apparently found, in accordance with the lease, that there were factual disputes as to whether or not, just as the state said, as to whether or not there was objective entrapment as a matter of law. Finally, in the Campbell case, Your Honor, the Campbell simply stands for the proposition that they didn't carry their burden to even be entitled to objective entrapment, to an instruction on objective entrapment. If you read the case carefully, there was so little that the defendant didn't make his prima facie case to be entitled to a jury instruction. That's how I read that case, Your Honor.
It's not how I read it, but go ahead.
And we would also rely on the Nadeau case, where it was decided. It's one of the leading cases from the 4th DCA. I believe it's NADEAU. And that was decided. It was an objective entrapment case. They reversed a judgment of acquittal on objective entrapment. So it can and should be argued to a jury. There's authority, there's precedent for it. And the denial of the ability to present our defense of objective entrapment, we believe, is both a federal constitutional violation of due process, the due process right to present a defense, as well as a Sixth Amendment right to a trial by a fair and impartial jury. Thank you, Your Honor.
Okay. My thoughts on this haven't changed. You're going to have to create new law if this, in fact, is a defense that could be presented to a jury. I mean, I've looked at all these cases that have been cited to me, including the ones that were just given to me by the state. I've already mentioned the Cruz opinion, which is the opinion that really adopts objective entrapment. And just quoting from that, we find that, like the New Jersey court, that subjective and objective entrapment doctrines can coexist. The subjective test, normally a jury question. The objective test is a matter of law for the trial court to decide. That was also repeated in State versus Glosson, Blanco, Campbell. And if you even look at the recent 4th DCA case, the most recent 4th DCA case dealing with this issue of subjective and objective entrapment, it's State of Florida versus Lang. It was decided January this year. The issue in that case was not whether, in other words, the issue in the case wasn't whether you submit objective entrapment to the jury. It wasn't squarely on point. But if you go through the analysis of objective entrapment, it is clear. The court repeats over and over again, the court must decide. For example, one of the things the court must decide is it must do a balancing act, a weighing between the state's right to prosecute a case and the defense's due process rights. So the court does the weighing. Those are all in the discussion by the 4th with regard to objective entrapment. I believe to give an instruction on objective entrapment would basically create law that doesn't exist. I'd also note that since 1985, objective entrapment has been recognized in the state of Florida. And in all of that time, not that this is controlling, but in all of that time, the Supreme Court has never drafted a standard jury instruction on it, which would suggest that it's not something that is presented to the jury. That's not controlling because the jury instructions, candidly, the way that the Supreme Court talks about jury instructions are more of a suggestion than a rule. So the fact that they're not in the jury instructions is not dispositive, but it is interesting that it's been around since 1985, and the only entrapment instruction by the Supreme Court is on subjective, and I think the reason for it is clear. Objective is not a question for the jury. So I'm going to deny the request for an instruction on that. And do you want to kind of, Mr. Rosenfeld, kind of finish your argument on motion for judgment or acquittal? That was one of your grounds.
Well,
We stopped in the middle of it because you said I said maybe we ought to take up that
I
argument.
already addressed the first round. Judge.
Okay, so-
Down to that.
So was there anything more you wanted to add, I guess, based on the discussion we just had?
No, I think we went through it kind of pretty thoroughly, Judge.
Okay. All right. State on the motion for judgment of acquittal at the higher standard. I mean, I've ruled on the objective entrapment, but there were other issues that were raised. The state's response. Okay. Ms. Roosevelt, anything else you want to say on that?
No, Your Honor.
Okay. I'm going to deny the motion for judgment of acquittal. I think there's sufficient evidence at this point to go to the jury on that issue. Are those the motions that I have to rule on?
You're denying on both grounds, right?
Correct. Correct.
I guess at this time, then, if it's an issue of law, we would renew our motion to dismiss based on objective entrapment, based on the evidence you heard, Judge.
Okay, we've already had, I don't know if there's an opportunity to readdress that, but what we're going to do is I'm not going to burn daylight arguing that now because I want to do the jury instructions consistent with the estimate that we gave, if we can, to the jurors. So I can do that at any time. I can dismiss the case
While they're deliberating?
while they're deliberating. I could dismiss the case after they've
I
reached the
agree,
verdict.
Judge.
Yeah, so I mean, if that's all you're going to do, I can do that at any time. So we get to the jury instructions. Did both sides have an opportunity to review the draft that I provided?
Yes, sir.
Okay, so let me kind of get comments from both sides.
For the most part, we're in agreement. We have one concern, and that deals with the criminal solicitation portion.
Criminal solicitation.
That's on the first page of Your Honor's
Okay.
draft. And we have some case law, and there's one I need to shepherdize, and I apologize, two that seem to be on point.
Which part of it are you objecting to, Ms. Rosen?
There should be an additional element, and we would add 3, Dalia Dippolito had the intent that Whitey Jean committed the crime. And I'm basing that on Florida Bar v. Mirably, 645 Southern 2nd 438.
Can you give me the slide again?
645 Southern 2nd 438. And I do apologize, I'm not seeing anything on the case indicating that there's a more recent case, so.
Well, I know this is the standard instruction. although
Sure, but Your Honor.
the standard's not always.
Yes, and it says elements of criminal solicitation are commanding, hiring, requesting or encouraging another person to commit crime, and intent that other person commit the crime.
What did you say again?
Oh, 645 Southern 2nd 438.
And what's the case?
Florida Bar v. Mirably, M-A-R-A-B-L-E.
Florida bar? Strange case, I don't, why would it Florida? All right, I'm gonna look it up.
And I'm bringing this up as it's addressed in other cases, this standard. And it also refers to 777.04, which is the statute for criminal solicitation.
So there's an attorney disciplinary proceeding.
And referees finding that attorney committed crime of solicitation of burglary was not supported by competent substantial evidence. It must have been a fun hearing.
Okay, so that's one request. You want a third element?
Yeah, and there's just two other cases, if I could give you the site, Judge.
Then,
State v. Gaines, 431 Southern 2nd, 736. And that's 4th District, 1983. And that needs to be shepherdized. I apologize, but it says, for the crime of solicitation to be completed, it is only necessary that the actor with intent that the other person commit a crime. And then it goes on. And intent is a question of fact to be determined by the trier of fact who has the opportunity to observe all of the witnesses. That's referring to State v. West, 262 Southern 2nd, 457. And I believe State v. Waskin, it's called into doubt, but not in reference to that proposition. And last, Inree Brinken America Equipment Lease Litigation, and that's 977 Federal Supplement 2D 1287, United States District Court, Southern District of Florida. If I can read you a quote from that, Judge. Under Florida law, the crime of criminal solicitation is statutorily defined as a person who solicits another to commit an offense prohibited by law, and in the course of such solicitation commands, encourages, hires, or requests another person to engage in specific conduct which would otherwise constitute such offense or an attempt to commit such offense. Thus, the elements of criminal solicitation are: 1, commanding, hiring, requesting, or encouraging another person to commit a crime, and 2, the intent that the other person commit the crime. And that cites the Florida Bar v. Marble that we referenced earlier, Judge. So we believe that intent is a necessary element of solicitation that should be included in the jury instruction. And as Your Honor is well aware, if there is correct law or law in support, it should be added to the special instruction.
okay. Let me kind of get your comments in general, Mr. Rosenfeld, and then I'll come back and ask the
Sure.
state about each one of them. So one is, in some way, add an intent element on criminal solicitation.
Yes, Your Honor.
Okay. What are your other comments?
We're fine on jury instructions, fine on statement of the charge, fine on introduction to homicide, fine on justifiable homicide, fine on excusable homicide, no objection to murder of first degree. I believe we do not want entrapment, subjective entrapment.
So you're not asking for a subjective entrapment instruction?
Correct, Judge. We are fine with no objection to plea of not guilty, reasonable doubt, and burden of proof. No objection to weighing the evidence.
On weighing the evidence, the first 5 are always given. After that, it becomes discretionary based on the evidence presented.
We would
assuming
want
you'd want, you want 6 and 7?
Yes, we definitely want...
Inconsistent always pretty much stays in there, but in terms of a witness being convicted of a felony or a misdemeanor involving crime of dishonesty or reputation testimony, has been under that, right?
I don't believe so. Let me just confer with my colleagues.
State anything you can think, any reason why you can think of to keep 9 and 10 in of the standards?
And we agree with the court.
And we strike 9, Judge. I don't believe there's any...
Well, there's no reputation testimony either, right, 10? 9 is convicted of a felony or misdemeanor crime of dishonesty. 10 is general reputation. It's reputation testimony. There's been no reputation testimony.
That's correct, Your Honor.
Okay.
We obviously want 8.
Yes, 6, 7, and 8 you've requested, and if you request, I'm going to leave them in.
Yes, we'll leave that in there.
I bolded the testimony of some witnesses to make sure that it applied and the parties were asking for it. Many times it's given when there's a co-defendant.
We'd actually like that in there in light of
State any objection?
Muhammad's testimony.
Okay, I'll just have to take the brackets out. I'll leave it in there. Obviously won't be bolded. Defendant testifying was bolded. I'm taking that out, obviously, and leaving in defendant not testifying, and I'll remove the bold. And you know what, State, you never sent me a verdict form, did you? Or did you? Did you? Okay. Maybe I just missed it. Let me. Were there any other comments before I hear from the State, Mr. President?
We have some more instructions. Oh, you're saying as to that one section?
Well, as to the jury instructions. Yeah.
I think we're still going through it.
Okay, that's fine.
You hadn't bold something on page 7.
What I bolded on page 7 is that the State always provides me with 2 things which are inconsistent. Either the defendant is a witness or the defendant is not a witness.
All right, so page, I'm sorry, why'd you bold that, Judge?
Because I have to remember to take one of the other out because they're inconsistent. It's my own purposes, so I don't leave both of them in. One of them says the defendant in the case has become a witness. The other says the defendant is not testifying. So I bold both of those so I know one of them has to come out, and I take the bold off of the other one. So in this case, because Mr. Blue did not testify, I take out the defendant becoming witness, and I leave in defendant not testifying, and the Constitution does not require it to.
So no objection to taking out that one paragraph, no objection to defendant not testifying, no objection to defendant's statements, no objection to rules for deliberation, to cautionary instruction. With verdict, I always ask that this court switch. You may find the defendant not guilty or guilty as charged in the information to go along with the presumption of innocence, Judge.
I apologize, there was a verdict form. How is solicitation to commit murder a lesser included crime?
Without the firearm,
Without the
Judge.
firearm.
There is no such crime as first-degree murder with a firearm. You'll notice when I did the jury instructions, pet peeve of mine, when I, with a firearm, the state charges with a firearm only if there's a it's only relevant if there's a reclassification or 10-20 life, right?
Right.
Otherwise, it's not relevant. First-degree murder is not enhanced, and it's not 10-20 life because it's a mandatory life sentence. So a firearm, there need not be any finding of a firearm with a first-degree murder because it's not a reclassification and it's not 10-20 life. So
Yeah, that was the original instruction. The only question I would have is, but we're talking about solicitation.
but how is solicitation has no lessers? It's either
But-
solicitation for first-degree murder or it's not.
But wouldn't the enhancement apply?
No, not to solicitation. And if it does, you didn't charge it that way in the information. You didn't say, you'd have to cite 775. I don't believe you did. To get an I mean, what you're saying is that you would, if there were an enhancement for solicitation, you're saying it would go from a first-degree felony to punishable by life, a life felony.
Right.
I don't think it applies, but not only that, you would have to, I mean, you put firearm in there, but you didn't quote the statute that would do a reclassification. I don't think, I'll listen to defense, I'm assuming the defense is going to support the position I just took. There's no reclassification of the solicitation. So with a firearm is of no significance. It's either guilty of solicitation to commit first-degree murder, or it's not guilty.
Okay.
Okay?
I agree with your Honor.
Okay. So I got to change this. Oh, and I'm sorry, I didn't rule on what you asked me. I'm going to leave the order the way that it is and it's provided by the Supreme Court.
So Your Honor's ready, I have one other issue with the verdict form, with the verdict section.
With the verdict form?
Yes, with both the verdict section and the verdict form, I always ask that you may find the defendant not guilty or guilty as charged in the information. She's presumed to be innocent, but guilty first. Presumed her to be guilty.
I've gotten that request before, and I understand what you're saying, but I'm going to deny that request because the instructions say you go from highest to lowest. So, no, I've heard it from others. The PDs do the same thing. You're not the first to give me that.
The final instructions seem to be missing a lot.
Okay, what are we missing?
In terms of standard jury instructions, I don't have it in front of you to pull on your computer. There's information about knocking on the door to know with any questions.
Well, I give them all that after this anyway.
Do you give that in writing? Because I know it's standard jury instructions.
No. It doesn't. I don't think the standard jury instructions say anything about knocking on the door. It
Not
says.
that, about writing a note, giving it to the deputy or something along those lines. I know we, Mr. Gideon, went through it earlier. It was probably a little more extensive and there was some reference to that. There's something about a note, I'll tell you that much. We'll get to that next. Take your time.
It's got a few, actually, it added a couple things. It's got the cell phone instruction, which I give them also. I can put it in there if you want. The duty to communicate, send a note to the court deputy, if that's what you want, I can add that.
I would say that's important.
I will, if you have any questions, I will talk with the attorneys. Those are all standard. So I'll be happy to add those back in. I don't think the set that the state sent me had those in there. Where did you get this instruction? Because it's not the most recent.
It's possible it was from the original draft.
No. I think I took them out because I thought those were already done prior to. I thought you'd already given them.
No, I always give them anyway, myself, but there are instructions that are part of the standard. Like I repeat the knock on the door, and I repeat the cell phone instruction. Okay. So we'll add those to the finals. Okay, anything else on the instructions before I hear from the state?
Last thing, Your Honor, we would ask to strike everything from the bottom of page 1 through where you struck entrapment, the top of page 3. We find all this stuff on justifiable homicide, excusable homicide, murder in the first degree, homicide can be incredibly confusing. And
It is confusing. I think the reason the state left it in there is there's some case law that suggests anytime you instruct on homicide, it's reversible error not to include those. Now, I don't know in a solicitation case that would apply. I think
I'm not taking my chances.
Yeah, I think that's why they included them. And if that's the case, I agree with you, Ms. Roosevelt. I think they're confusing. I think just a definition of first-degree murder would be appropriate, but there is some concern about it. This isn't a first-degree murder trial. It's a solicitation trial. I'm not sure they have to be in there.
one more, Your Honor. Yeah, Judge, it's only reversible error. I mean, if we waive that appellate issue, it would not be reversible error.
Actually, I think there's a case that says it's fundamental error.
All of it, or just,
The case law says, now again, this is a little different because she's not charged with first-degree murder. She's charged with solicitation, okay? So it's a little bit different. But the case law is that any person, when you're giving an instruction in a first-degree murder case, that it's fundamental error not to give the introduction to homicide instruction. Because it defines when a killing is not unlawful, when it's justified and when it's excusable. I tend to agree with you probably in a case like this where it's really a solicitation, it's really not a murder case. Probably it's not necessary, but if the state's objecting to it coming out and it's been held to be fundamental error, I'm going to err on the side of including. I think it is a bit confusing, but I don't think it hurts anything in the long run. I don't think it causes any issue if I leave it in. So that's my ruling.
Our objection to the record is inflammatory, misleading, incredibly confusing for the jury.
Well, it just describes when it's not unlawful.
Your Honor, respectfully, and I agree to accessing the word killing 4 times in this instruction. And this is not a killing, this is a murder case. If Mr. Williams wants to argue a closing argument and define murder or homicide for the jury, I think that's fine. If you really think that's necessary for a jury to understand what murder is, but I believe this jury, there's 2 pages to the record. Take a look. Just to the record. There's a definition of criminal solicitation. Then below that, there's an introduction to homicide. Now, if I'm a juror, and I'm reading that, I'm going from criminal solicitation to introduction to homicide, then I'm thinking, ding, 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 wow, murder. This is a murder. Wow, she's killed somebody? I mean, then they're going to start thinking, wow, she killed somebody, maybe killed somebody. Maybe I need to find her guilty. Top of page 2, a killing that is excusable. Then they're going to be thinking, was there a killing? Why is it excusable? Who was killed? Why is it excusable? Justifiable homicide, it does nothing. Then excusable homicide, then murder in the first degree. This is as inflammatory as I've ever seen on a jury instruction form. And Your Honor's initial inclination is correct. This is a solicitation, criminal solicitation case, not a murder case. There's no need to define 4 other types of murder in this instruction form to try to impress or intimidate this jury that they need to find her guilty with the word killing in there 4 times. I just don't see there's no social utility at all, Your Honor. Why is all that in there other than to confuse the jury and to inflame the jury to find her guilty?
I don't think it's in there for that purpose, but I do tend to agree with you that I'm not sure that it's really necessary. I'm going to hear one more time from the state.
Judge, it's not worth the risk. I'm asking you not to just leave it in. We can, if they want, they can tell the jury it doesn't apply. I'll tell them that myself, it doesn't apply. But leave it in there, because otherwise there's a chance it could get reversed.
But every case that's dealt with this has been a murder case, right?
But you still are giving them a first-degree murder instruction. What the case law says is when they're instructed on first-degree any murder, there should be an introduction to homicide, period. And if it's not, it's reversible error.
This is a murder case, Your Honor. This is not.
I know. What he's saying is that when you're instructed on murder. Okay, I'm gonna leave it in. I think you guys, I don't think they're gonna be confused about whether there was a killing. There's been no evidence in this case of an actual killing, and it'll be clear in the closing arguments that there is no such evidence. So I understand your objection, Mr. Claypool, but I'm gonna leave it in.
May I then inquire on a couple of If you want to have an introduction to homicide, okay, fine. Why do we have to have justifiable homicide, excusable homicide, and murder in the first degree? Can't there be some way to consolidate whatever it is that these folks are trying to explain to the jury? I mean, this is what's
required. This is the introduction that is required in the cases that talk about instructing a jury on murder. This is what has been held to be, albeit in a murder case, fundamental error not to include these instructions.
Your Honor, respectfully, and you've been tremendous in this case. I can't believe the depth of knowledge you have of the law and order off the cuff. I mean, it's amazing. But and I say that with all due candor and high respect for you. But I've got to tell you, the definition of excusable homicide. The killing of a human being, here's the definition for the record on page 3. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. That first part of that sentence, the killing of a human being is excusable, implies that there's been a killing of a human being in this case. This is clearly designed for a murder case and is highly, highly misleading to this jury and extremely inflammatory as they believe it. It's just not appropriate for this type of case, Your Honor. Wouldn't you agree, Your Honor, the killing of a human being is excusable, that necessarily implies that a human being in this case has been killed? I mean, is that a fair inference from that?
Well, even in a case where sometimes the instruction is given where there's a disputed fact as to whether there's been a killing. But I understand what you're saying, Mr. Claypool. I'm going to fall back on the case law as I understand it. I do think there may be a distinction here, but as Mr. Williams has said, I'm not going to chance it. I don't think they're going to be confused by this at all, because they're going to know it's not a murder case. It's never been presented as a murder case, and it'll be clear in closing it's not.
Thank you.
All right. Were there any other requests from the defense? I need to get to the state and see what the state's comments are. Let's begin with probably the most important thing, criminal solicitation. What was that?
I think you have a copy of our objective entrapment instruction.
Yes.
Now is the time to raise that. We're requesting Your Honor without that.
Okay, I'm going to deny that. But you want to file that. I guess it's part of your motion. If you want to file it independently and make it a court exhibit for the record, it'll be easier for the fourth to review it if you want.
Sure.
Okay, so just file that word perfect copy of the set I told you to make, or I can print it for you, one or the
Well, I
other.
believe we have it in the motion for special.
You do. What I'm saying is if you want to file it separately, you can file it separately.
I'll do that tonight. That's fine.
Okay. All right. State's position on intent.
I think it's implied in the instruction, but
Well, I mean, if it may be, but should it be added as a third element? Or should it be in court? I think intent based on the
You would
case.
say Dalia Dippolito intentionally solicited Woody Jean to commit first-degree murder, and that's where it would go.
No, that wasn't what the case law says, though, I think. I think the point they were making is with the intent that Woody Jean commit first-degree murder.
Correct.
I mean, it could be included in the 2 elements. It could be Dalia Dippolito solicited Woody Jean to commit first-degree murder, with the intent that Whitty Jean commit first
We'd
degree.
like it separate, just to be clear.
So what do you want, a third?
Elements.
The third element, they're asking for a third element.
That
Fine,
Whitey
Judge.
John commit
It's fine.
Hold on. What do you,
Fine or not, Judge?
just please tell me what it says.
Dalia Dippolito had the intent that Whitey John commit the crime. Or commit the crime of first degree murder, however you want to phrase it.
So let me make sure I have it. This, by the way, is one of the reasons I raised this scheduling concern, because these instructions won't be ready when we told them. Dalia A. Dippolito, give it to me again.
Had the intent that Whitey John commit the crime.
Any change in the wording or suggested change in the wording from state? Is that all right?
That's fine, Judge.
So we'll make it 3 elements. Okay. All right. I think, now, other than the requested changes by the defense, were there any additional by the state?
Yes, Judge. We just left out a bunch of stuff for first degree murder. I think it has to track what it says. It's got to be to prove the crime of first degree.
I disagree with you, because what, that really is confusing, because then because if your first element is that Michael Dippolito is dead.
Right.
No, I mean, all you have to do is define the crime, okay? I don't think you have to go through each one of the elements. You're not proving those elements. You're proving the elements of solicitation. You have to define the crime.
What are we referring to again?
We're referring to, under first-degree murder, the way that the state originally prepared the instructions is it says the state must prove the following 3 elements beyond a reasonable doubt. Then it just listed what you'd normally list in a murder case. That number 1, I think, was that Michael Dippolito is dead, which is obviously not a fact. 2, that the death was caused by the unlawful act of Dalia Dippolito, which is obviously not true. Those are just elements of the crime. I think all we have to do is define what is first-degree murder, not put the elements in there, because I think that Mr. Claypool would really have an objection with respect to confusing, because there is no first-degree murder here.
We just got a case that actually
Supports your position?
And your position, Judge.
Give it to me.
Penna, P-E-N-A, v. State, 901 Southern 2nd, 781.
Southern Second? 901 Southern Second, what was the last?
781, Florida Supreme Court, 2005. And if I can just read you the question. The issue is fundamental error of the trial court to omit instructions on excusable and justifiable homicide when a defendant is charged and convicted of drug distribution, first-degree murder under Section 78204, subsection 1A3, and the factual circumstances do not support any jury argument relying upon the excusable or justifiable homicide instructions. And it says C, Article 5, Section 3B4, Florida Constitution. We answered both certified questions in the negative. So it is not fundamental error.
Is it passed?
Yes, no.
The second DC decided not to follow. I don't know why, it's the Supreme Court, right?
Yes. Once again, I apologize. It's hard to shepherdize this right now on my phone.
It's got a yellow flag.
Yeah, but the yellow flag is from a lower DCA. They can't overrule the Supreme Court. I'll check the yellow flag, but I mean, it does say that. I mean, I think it's been correctly cited. It was on a certified question. Second DCA certified the question whether it was fundamental error for the trial court to omit instructions on excusable and justifiable homicide where the evidence does not support these defenses. think it supports the defense's position, is what I'm saying. See if there's anything here I keep this in here. Okay, anything further from the state?
No, sir.
Okay, then I'm going to reverse myself. If it's not fundamental error and the defense is specifically asking for its removal, I'm going to take out introduction to homicide, justifiable homicide, and excusable homicide, and leave the definition of first-degree murder as I have. Anything else from the state?
No, sir.
Okay, this is going to take me a little bit of time to revise these because I have to change the final instruction. And so I'll do it as quickly as I can, but it's going to be at least 10 minutes before I'm ready to come back. Any other changes to the instructions?
No, sir.
Okay, all right. Then give me a chance to do these revisions. I'll be right back.
Oh, yeah, great. Yeah, got a good memory. That fella. Oh, I thought he was being funny when he saying hello. What's that for? One day, but I don't know. Yeah, it's one. Well, yeah, it's one.
This one.
John brought him to the party last night, so it was very nice. Well, I came this morning. I wouldn't work all day. Less than an hour drive. Got here early. The year's ending, and I feel like a marathon. That's the problem. You got 25 years of NBC marathons. So, step up there. If the jury is...